So the idea for tonight was really to talk about what smart contracts are, how to be able to examine the contracts in the legal industry, and then we'll have a short 45-50-minute panel. We're going to open it up to you guys for questions. Just so you know, this is being live streamed, so you should just be comfortable with that if you're asking questions. So, just to start, I just sort of sense a little. Who here knows what a smart contract is? Okay. Who's not 100% sure? I'm saying my hand I just want to give that panel just a brief moment just to give a little bit about their backgrounds. But after that, I think it would be helpful just to set up some definitional terms we know what we're talking about. We have to understand what the smart contract is for the purposes of this conversation because there are multiple definitions. So just turn it over to the panel.
I'm David Whitaker. I'm senior counsel at BuckleySandler. I've been a banking lawyer for about 33 years. And about 20 some odd years ago, I was there at a bar in Boston at the Cohen Marriott when the American Bar Association Cyberspace Law Working Group, later committee, was first created with the immortal words, you know, this electronic shit is going to mean something. And sure enough, the Cyberspace Committee was instrumental in the creation of the Uniform Electronic Transactions Act. I also had something to do with the creation of the Federal Electronic Signatures and Global National Commerce Act. The global was a meaning thing, we just needed the G for the acronym. So I have worked on electronic financial services for the past 20 years or so. Aaron asked me to join the panel largely because at some point I could fill you in a little history as to why UETA and ESRA actually go a goodly ways towards establishing a legal foundation for smart contracts, because the folks who wrote it in 96 to 97 were actually thinking about these scenarios at that time.
I'm Dewey. I am a partner at Holland and Wright. In our Miami office, where it's a little bit muggier than it is here. I've spent the last 19 years practicing primarily finance, both commercial real estate finance as well as asset-based financing, and have been a computer programmer since I was 8. And somehow oddly enough it converged again.
Hi, my name is Cohen. I'm a partner within the Lovells and our New York office. My background is in structured finance, and I've been doing that for a number of years, and I choose not to disclose. My interest in blockchain came about because I'm a member of the board of the Trade Association for Industry Structured Finance Industry Group, and about a year and a half ago, a light bulb went off, and I said, as we said, blockchain things, it's going to be big. And I went to the board and said, I think we should do something with this. And the board agreed. And so I'm leading our blockchain task force within the industry. And that really narrowed on the reasons that we may touch on. We see blockchain as being a critical piece of finance across the world. And I'm proud to be part of a firm that has a very deep and wide blockchain team, including partners who's here today, and lawyers across the U.S. and around the world.
So I'm Jason Rozovsky. I'm an attorney at R3. We work with a consortium of 80 plus financial institutions and regulators. We do a lot of experiments at the moment, working projects, trying to see where blockchain fits in, where the banks may want it, and where it works. We're also developing a platform. We open sourced our code Corda back in November. And so many of you may have heard that at some point we're doing a lot of experiments, but I think now we're kind of focusing and looking to what is commercializable, where are the products, and as a R3 folks at last a couple weeks ago, this hopefully is the year of the pilot for us.
I realize I can introduce myself. So I'm Aaron Wright, professor here at Cardozo. I run a technology clinic. We also I'm the director of our soon-to-be announced and moving forward blockchain project. For whatever reason, the faculty is deeply interested in blockchain technology. I just finished up a book, which is going to get published by Harvard Press, blockchain technology and law. I've represented and also the clinic blockchain technology. So I think really, I worked hard to prepare this panel. This is the expert panel. If you have questions about blockchain technology and how let's talk about smart contracts. Right? So who here thinks a smart contract is just a really, really risky and legal agreement? Who thinks it's that? Well, it's really not, right? A smart contract, I think, in its broadest sense, and that's what it is, right? It's really a bit of computer code or computations that run on objects. And those computer code or those computations can be used for a lot of purposes. Right? They can be used to power decentralized applications. It can also be used to model out all of the parts of legal agreements. That's what we're really focused on here, is the use of this smart contract code running on this distributed network of computers and how that can be used to model out legal agreements. So I guess this panel can move on that technically. And if we're talking just about other types of contracts, maybe we'll call them digital contracts, some legal scholars call them computable contracts. For now, it's really focusing on special types of code that runs on blockchain that is these computations that run on distributed networks of computers. So I guess the kind of first question that I want to pose to the panel is, why is the legal industry doing this? Is it just because they sound like they should be legal agreements, because they're called contracts, or is there something more? Why would we actually want to use smart contract programs for legal agreements?
I would say, Aaron, the number one reason is for efficiency. The fact of the matter is, why do commercial parties enter into contractual arrangements? It's not to keep lawyers busy. That is not the primary objective. The primary objective is to conduct business, to engage in commerce, right? That's why you have contracts. And the more efficient commercial parties can make their arrangements, the more desirable those arrangements will be. There's a tremendous push to effectuate commerce in the most efficient way possible. And I would argue the number one reason for using smart contracts is it's a way to make business arrangements more efficient.
I would second that. I'd also note that it's not so much the legal industry driving us towards smart contracts as it is our clients. They're going to use them one way or the other because of the significant decrease in transactional costs and host of other benefits. So, whether we like it or not, it's going to happen. But I do think it's a far superior way to engage in commerce.
I think it can particularly be useful, and there are a lot of different use cases, particularly when anytime you're talking about delivery of rights against freedom. Blockchain is particularly useful in that environment. And that's an environment where today we see a lot of time and expense invested in these intermediaries. It's basically a no value, basically a no value expense deduction of the transaction. It involves time, it involves personnel, it involves the possibility of error or allocation even in some cases. We've all seen that in one line or another. So to the extent you can automate delivery of value against delivery of rights using blockchain technology, the efficiency gain is not only tremendous, but there's also, I think, ancillary gains in terms of certainty, in terms of disintermediation, in terms of the fact protecting the transaction and making it more secure.
Yeah. And I think, a lot of the clients that Joe mentioned, they're trending toward the outsourcing of non-differentiating services, right? You're not going to a bank like Goldman because they're very good at reporting a transaction. And so those things that before were done by human beings, like the call centers in India, for example, or whatever other trends there were, it's technology now that they do. And cost and efficiency is really, I think, why banks today are looking at this and saying to themselves that, they'll be able to not only disintermediate third parties, but also in some way, shape, or form, reduce their own costs internally as well.
It's also, Dave, want to pick up something you said, because I think it's a critical point you just made. And that's this distinction, when we talk about smart contracts, between code that is used to affect a delivery versus payment, and code that's used to affect some sort of executory arrangement, which takes place over time. There are tremendous differences. I think that's a nuance that you as lawyers, or those of you lawyers, will appreciate, but many don't. We'll come back to that, but I think, David, that's a critical point.
Yeah, and the reason that there's these efficiencies is because once you deploy the code on the blockchain-based network, it becomes independent of any one party, right? All the parties on the network, at least if it's a large blockchain like Ethereum, all the nodes on the network are going to run that program. So you can't really stop that code from running once it's deployed onto the network. So that means that you can automate certain transactions. It also means that parties could, by default, have a hard time backing out of certain transactions. So you can add a degree of rigidity to a promise that otherwise you may lack if you're using that some rating products. So if you're binding together some payment obligation, you can make that payment obligation a bit more rigid than what's possible with the natural. And I guess they also touch on this, but here's the clarity point. So when you begin to memorialize agreements using source code, especially the payment obligations or other really verifiable facts, it might actually add some clarity. I don't know if you guys have ever explained extracting mathematical formulas in natural language, but if you have a choice of doing that, or writing it out in the code, which is native and not really mathematics involved, it's usually much easier to pass here. So
There actually is kind of a legal analog of Williams. It's called letter of credit. Documentary payment is a documentary credit. If you've ever dealt with someone who on a regular basis drafts them, it gives me kind of an exercise in if-then 1-0 program. If the following information in the following form is presented to us in this manner and in this time, we will pay $1.5 million on the slot machine. Right? No questions asked. So if you just imagine automating that one step further, where the necessary information is delivered into a blockchain environment, and that causes then that environment to immediately pay like a slot machine. So probably the closest you get in ordinary day-to-day financial services practice to programming language is writing letter of credit documentary agreement.
So they're the first step.
First up, executing.
And just, some of the manual letter of credit usually wasn't, especially in trade finance, it wasn't just presentment, one presentment. You work through 8 correspondent banks and really, agent all the way back to somewhere in Ohio, which is just an incredibly inefficient process.
So you guys, when you're thinking about smart contracts, or using smart contract programs to model out legal agreements, are you envisioning that an entire legal agreement will be modeled out in smart contract code, or will it be part of this agreement? And what is it going to look like as practice that this technology gets deployed and used to analyze contractual agreements?
So, yeah, and I think that, at the moment, regulators are not necessarily fully educated. And so when it comes to regulated institutions, there could be short-term, medium-term, and long-term ways that this plays out. We're seeing short-term, medium-term, hybrid agreements with some network agreements or some transaction-level agreements in writing to cover, things like errors, right? That may come up, and then maybe have, the actual transaction-level agreement in code, but in the short and medium term, we're seeing that it would most likely be some hybrid agreement.
I agree with that. I'd say there are, in almost every contract, terms and provisions that matter greatly to the parties, an indemnity provision, representations, a variety of clauses that are highly important, but really not readily susceptible at all to coding out in some kind of if-then format. So I share Jason's view, I suspect, the panelists, that almost for sure there will continue to be a need for a hybrid, with some portions in code and other portions in standard legal language. Here's the other nice thing.
Yeah, I mean, one interesting thing is if you look before distributed ledger systems, most computational contract research was done with markup languages. So it's just some variant of XML, which doesn't really give you functionality. It's really a messaging system more than anything else. It's like for, again, centralized databases that communicate with each other by through embedded metadata. And this is something very different. So I agree with both of you that at least initially you'll continue to see things like fuel integration and Cardian contracts, but ultimately you should be able to get to a point, and that gets sort of the holy grail, where you can have the human prose, the parameters, and code in one data object that can somehow ultimately convert itself back into human prose if needed.
Yeah, I mean, I think that's interesting. So I think that kind of covers the gamut. Like, there may be some long-term instances when you're going to have an agreement entirely with the smart contract code. There may be some additional abstraction above that. But in the short term, you're probably going to see these hybrid agreements where there's an answer review assumption that incorporates the code by reference and somehow covers a portion of the performance obligations to parties. And those two will need to sync together in some sort of way. I guess if that's going to be the framework, then what doesn't change the smart contract contract? What do people still need to do in order to memorialize it to these treaties?
One of the things I want to do, and I wonder if you know that, one of the conferences is the contract negotiation. Frequently, the least important part of the contract negotiation happens when you finally sign the agreement. And the more complicated the relationship, the more that's true. Because what happens, and I know all of us here think of 150, 200, 500 page contract, right? Where the converters and the conditions and the subconditions and the alternatives, they're all laid out in excruciating detail in this contract. And then they go off to be implemented by human beings who immediately forget 75% of what's in that document. But that wasn't the point. The point was that the two parties, or the three parties, or the five parties, and their lawyers went through the exercise. And by that exercise, actually tested out each other's expectations concerning how that contract would be performed. One of the things that I'm kind of curious about is when, how, and to what extent we can get comfortable with the notion that that conversation will happen in some sort of automated way, rather than the way it happens today. Because one thing also that anywhere in the room or any of us up here can tell you is boy, does it frequently turn out when you get to page 32 of that 100-page contract that no, they were on the same page about how one thing or another was going to happen, and there's an explosion sometime during the negotiation. Very common. So, is there that going to be some kind of natural break at the short term on how far this goes?
I think for those who have worked, this is another concept that we haven't introduced yet, but because it's code, right? Code to read and write. It's not just a messaging platform. It's not just a one-way communication or package of communication. So you can structure these contracts so that they can be different. So this is, I think, what's by the leading edge when it comes to this type of thinking. But how do we build that out and more open-ended contracts that rely on oracles or outside data sources to manage certain things? So you can imagine there's an oracle not just feeding in the price of wheat or interest rate or something like that, which is what they're thinking about, but actually anybody with a decision. You have a very small short-term expectation to deal with disputes. So I know people with things for consumers actually do that pretty well, but I think that's the idea. Much easier. We're not really defining everything. And if there's a point of decision making for parties, they either both say, well, Very good. You structure that one. I think that's.
Yeah, I would go back to my point that I was making. The reason I think we're writing contracts are a short-term fix is because until you get down to something that's far more structured, then we're not going to be able to use a lot of the tools. Software developers, when they write code, and I mean, it picks up most of your mistakes. If you have undefined terms and you try to use a class that you a library that you import it, it class it. And those would be very helpful tools for lawyers. Because when you're drafting a 200-page contract, you're making mistakes. It's just when it comes back and bites you.
I'd also like to pick up a term that a couple of us have now used, the Cardian contract, and it's a term you see in the States used a fair amount. To my mind, what most people mean when they use that term, the Cardian contract, is a hybrid contract, but where you have code that can resolve into human language. That's different, at least to my mind, than the kind of hybrid contract that I see. There are efforts going on now to create syntax and formulae where this parameter can fit in with that code, and there's a sort of table that everything plugs together. There may be very narrow areas where you can create that kind of hybrid language, but I think for most of what lawyers want to do, to be confined by such a system will limit the ability of commercial parties to reach the kind of agreements they want to reach. And instead, they will simply say this portion of our agreement, this allocation of cash, whatever it may be, is defined by code in Solidity, in DAML, in Corda, in whatever language and platform you choose, and not trying to have this magic code that somehow flips from one to the other. I personally think that's, in most cases, a fool's errand. The only other quick thing I want to pick up on is a critical distinction also from an economic point of view. High volume but low value contracts, where Aaron, I think your point is extremely well taken, that it's crazy to try and resolve disputes in those contexts, anything other than some kind of distributed system. But in high value contracts, parties are always going to want to resort to all means available to them to resolve their dispute, and not allowed. So I think that's an important distinction.
Yeah, that means underlying all these contracts, it's not like the law is the national concern. It's not like this notion of code is law, which is something that it's hard to just because you have a contract of some sort of thing. There's smart contract, you can model that to go through that review contract. Doesn't mean that you can walk into court after that, you kind of court interpret that in some sort of way.
Yeah, code can't put you in jail.
Yeah.
The judge can.
And that's been unwind too, right? So even if there's automatic money transfer, it doesn't mean a judge can't have the tax say, you have to do that back, right? And it needs steps you need to do that.
And U.S. courts are extremely adept. One of the things that we heard back in 95 and 96, when we started talking about doing contracts in electronic form using electronic signature, was, oh my gosh, what are the courts going to do with it? The courts have proven to be very quick on that thing, and have gotten very good. See, they were really excited. The contract law basically in the United States has been pretty much the same for about 300 years, and it dawned on them around 2000, 2001, down at the courthouse that they had a whole new area to play. For the first time in like 300 years, where there was an opportunity to write new common law in the United States on contract, and they didn't have in front of it. But they also mostly did right most of the time. And one of the best decisions I've seen with respect to electronic contracting was written by the 94-year-old federal judge emeritus here in New York, who got all of it and proceeded in an 83-page opinion, books and verses go really to lay it all out. So the courts, one of the things I did not assume, is just because we're doing coding, that the courts are going to be dormant. buying this. They're going to work through this just as they work through electronic contracting and electronic signature. They'll work through this as well. And so, to your point, the law is not going to evaporate. I have a friend who's an area who I think should even possibly refer to an acquaintance who's written a book talking about the prospect of code after law. I don't really follow, I don't know if the other folks on the panel, I don't really follow in that particular claim. I'm not sure.
Yeah, I think the only area where these agreements really become binding is when the parties that don't know what is there's no relationship between one another, and they're using the rigidity smart contract code to enter into a binding. That rigidity creates a request to enable commerce to occur. If that happens across the jurisdictional boundary, it's really no different than what would happen today. It's really hard to enforce contracts across jurisdictions, especially if they're own. But if parties are known to high value, then you can anticipate that.
And this one's a practical enforcement issue as opposed to a lack of law.
Right, so I can't actually enforce that as well, and then really articulate it's not but before we talk about, we talked a little bit about these earlier contracts that were interesting. Maybe just so we can describe kind of the landscape a little bit more. Well, what types of agreements are you seeing financial institutions experiment with? I know that there's still a lot of concepts that are emerging, especially in the financial services context. I also know there are some law firms and lawyers that we try to build through agreements. So I'd love to hear kind of what you're seeing now.
Sure. So first things first are the agreements that are susceptible to objective triggering events, right? Templatized agreements. So ISDA agreements, insurance contracts. You're also seeing those outdated systems. So, for example, with syndicated loans today, I think the estimations that there's 25 or 27 million pages being faxed each year in that industry.
That's
Danny, what's a fax?
You're also seeing it in those areas where there's redundancies in processes. So in the AML KYC world today, there's a lot of work getting towards sharing those services to try to rely on other financial institutions or consortium of financial institutions to address kind of the issues of getting to know who your client is and running all the right checks. And the other side is the reporting ones, right? So anywhere that there's reporting requirements, and that's especially in the post-trade derivatives world. And right now we're also exploring asset-backed securities as well. And I know Lois is going to speak about a certain insurance contract.
Yeah, so we're fortunate. One of my partners was here, and a couple of my colleagues. We sat down and kind of scratched our heads and said, what's an area again where smart contracts could be used, and a number of our clients and our insurance practice have been asking questions about how the smart contract works. Ira Schaefer was there, and a couple of others said, well, let's sit down and write an insurance contract and see what that looked for a disaster. And it proved very instructive. But essentially the process of having to go through and work that out raised a lot of interesting questions and helped our thought process really develop. And in fact, in that process, the guys coined what I think is a tremendously clever term, that is a smart term sheet. We talk about contracts, we talk about smart contracts, but we sit down and think, well, how do you go from business people who have an idea, okay, if an earthquake occurs in New York City, gee, I can lose a lot of money, I'd like coverage of that. And they lay out certain terms, okay, I'm willing to pay for that coverage. Well, there's a lot of different terms that go into that has to be translated before you can write code. And one of our fundamental philosophies is that business people can't go to coders and say, you write that up as a smart contract code. Lawyers need to be involved. There are all kinds of issues that, in terms of practice and drafting, that lawyers need, and how do you get there? And so they coin this term smart term sheet.
I would say, the low-hanging fruit is obviously letter credit, commercial paper, the more standardized documents that have 2 or 3 sort of conditions in them. An insurance contract, especially something like a life insurance contract, would be pretty enormous.
Probably that. You didn't go for life insurance.
Yeah, well, someone proposed that to me, I took a pass.
The Digital Chamber of Commerce actually in December, did a thing called Smart Contract Alliance. And they actually put together a white paper on the website. Talks about roughly 12, 14 use cases for smart contracts. So they list here like land title reporting, digital identity, financial data reporting, over-the-counter derivatives, drug trials and drug trial approvals, clinical trials for big pharma, automobile insurance issuance, issuance of policy to get into the numbers. Kind of an extension of what you see today, where how much my policy costs depends on how well I drive and how many miles I drive is being recorded by the vehicle in my car. The thought is that can be extended to the administration of the policy and the management of claims as well. So you may want to, if you just Digital Chamber of Commerce, you go to Google and put a Digital Chamber of Commerce smart contract white paper, if you're going to do it. And they've got them diagrammed out, 14 different model transactions that would benefit a smart contract.
Yeah, and I would take some of those with a grain of salt. I don't know if they're technically contracts and some of those.
Some of them, let's just say that some of them were more imaginative than others.
Yeah.
Well, I think you see there's sort of 2 buckets, right? I mean, some things are more process oriented, and other things are contracts. But the process oriented stuff can be just as valuable as if not more.
Yeah, I guess the only thing that we can touch on, which may be the actual ultimate use case for this, which is machine transactions. Right? So it sounds futuristic, but machines are transacting, IBMs are putting together a number of concepts where machines are engaging in commerce with other machines. We've already heard how Bill Gates wants to tax robots, so we're going to come to a point in time where we're going to engage with autonomous machines, and those machines are getting some sort of medium in order to communicate with us and get valued by us. And they're not going to slip paper agreements. Through like a scanner into some sort of machine. We're probably going to communicate that in some way, and presumably through smart contract code. At least that's what people are articulating as a use case. So I know that there's a number of startups in that are exploring this. I think we're going to start seeing a lot of interest in that in the next couple of years as well.
We were talking about before, I think high frequency trading accounts for something like 80% of all stocks traded. So it's really just an expansion of more complicated arrangements.
Yeah, and if you probably look at it, like exchanges or other meetings that are being facilitated for exchanges to be
So I thought a good question would be, so you mentioned oracles before.
Yeah.
And Lewis, mentioned historically insurance contract. And the oracle for that would, be some data feed from the National Weather Service website. So I guess, a question would be, what happens when those data feeds and those oracles have their own data restrictions, right? So today, a lot of data resellers, for example, may have to pass through terms, from the original data source. So how would you go ahead and account for that if, let's say, you have a fully smart contract, or even if it's a hybrid agreement? How would you be able to account for those terms, and who out of the contracting parties would be responsible if there's a breach of the license?
So they're fascinating questions. I'll just pick up on that. I think the answer is that there are whole new business models here in terms of how data is aggregated, how it is sold, how it is valued. And I think the clients we're working with that are foresightful are starting to build out those models that allow data to be used in a manner that would be consistent with a smart contract or you're absolutely right. Some data sources that work for one purpose may not be readily used for another. You also touch upon a critical point of Oracle, which is we want this all to be automated, but sometimes things go out of business or if things change, LIBOR may no longer be used as an interest rate base. How do you address that in a smart contract? What flexibility do you have? And can the parties get together and amend their arrangement? That's another critical question. In a bilateral smart contract that's very viable on an open network like Ethereum, it's too bad for you, most likely. So it's an interesting question having that concern.
And I think what's also interesting is that this, in some ways, for lawyers, is just not that new, right? We've been thinking about electronic contracting since probably the 1970s with these electronic data interchange systems, EDI systems, which many lawyers may not interact with, but which are quite popular, especially if like a manufacturer that has a significant supply chain. So I guess, going back to David's point before, if the court does look at this, are there any lessons that we can draw from these earlier legal agreements? How does the UETA, Lease Act, and some states, other state law variants and regulations, how are they going to benefit this?
Well, one of the things that we've all had experience with is recently, and when we were talking about this before the panel started, we've all had experience with someone showing up on Georgetown. In my case, it was actually the state government with a draft blockchain statute. And the statute was going to make it say blockchain technology can be used to create an electronic signature and a electronic interaction, autonomous interaction between data systems can produce an enforceable contract. And we sat down with the folks who brought it to us and said, don't need any of that. Your state already has the Uniform Electronic Transactions Act, which already contemplates all that. There are provisions in the UETA, and there's like an equivalent provision in the ESRA Act, Federal ESRA Act, called the Electronic Agent Provision. And it in turn essentially validates the enforceability of what it calls automated transactions. And if you actually read the definition, I'm not going to bore you with them, if you read through, there's a thing in the UETA called the reporter's comments. The reporter's comments were actually drafted by Ben Beard, the professor who actually wrote the UETA, explaining what they were trying to accomplish. You'll see what we've been describing on this panel was contemplated by the UETA drafting committee, and then in turn by Congress in the passage of something. And they expected this to happen. So they laid the groundwork. Now, there are gaps. We were talking earlier about the fact that like we made a mistake. Particularly when mistakes and step back and mistakes in the programming, not in the actual contract itself, but in the programming of the contract. So we created something new and the programming. Right? There are gaps like that that aren't being addressed. But the core concept that a pair of computers can have a meeting of the minds, and legal terms of what is supposed to happen for the course of the contract, is enshrined in the UETA. So, and we see instantly elements of that today. I actually brought with me a copy of a recent judicial decision, one of the first ones I've ever seen that talks about the electronic agent provision in the UETA. That's from South Carolina, Supreme Court of South Carolina. And it involved an insurance company that had a computer essentially say, yes, you now have an automobile policy, your automobile policy is issued. And the plaintiff in that case was arguing that the plaintiff was not bound by certain conditions of that insurance contract because it had not been issued by the human being. It had been issued by the computer autonomously. After the customer finished filling out the application, said, here you go, here's your insurance policy. And the court, quite rightly in my view, took one look at South Carolina's UETA and said, sorry, you lose. Because in the electronic agent provision, the insurance company can empower its online system to issue that policy. And that's just what they did. So we do have some limitation how the courts are going to look at this. And very open-minded.
You were closer to the process. I can't imagine anyone ever said, once we get another application layer on top of this, we're going to have to reconsider. Who knows? Because at the end of the day, a lot of this, that's just all it is. It's like another layer on top of it.
The definitions are so broad.
Yeah.
Electronic, they deal with electronic signatures, electronic records, electronic pages, all the things that are contemplated by these blockchain systems. So much to the actual credit, they foresaw or anticipated that this was going to occur. Even beyond that, just setting aside specific statutes, there's also robust common law, right, which would say that if parties decide to reach an agreement, it doesn't really fully matter how that's memorialized, that you can do the contract for the dealing or whether it is necessary. And obviously, the UETA is going to fill that, to fill the gaps with an arcane common law statute, mostly statute of frauds, which is very old, but yeah. But just undergirding this, you just realize when you're thinking about this, that the court is so well better to use a flexible common law system that we have in the US to deal with these types of issues, and presumably, especially in New York, with find a contract with this. I guess that's another thing also. New York is a little bit different when it comes to the kind of contract. Right? We've got a special statute that actually contemplates most of what Jason and Arthur are thinking about.
The New York electronic signature records ESRA, or just ESRA in New York, and not the rest of the country trying to mention that it's in New York. It basically comes down to two sentences is what I tell people. The first sentence is electronic records good. Second sentence is electronic signature is good. That's it. Okay, good. That's it. But there is also, and Aaron and I were talking about this on the phone a few days ago, there was also a New York judicial decision that says, and when they did that, and then later on, initially, ESRA had a terrible definition of electronic signature. And they changed it, and made the definition of electronic signature in the UETA e-sign, and shared the definition of electronic signature. Very good. Okay? And the court had said, well, when New York decided to change that definition of electronic signature, what the New York legislature was actually doing was adopting e-sign as the law of the state of New York. So kind of the position most practitioners take today is that for all intents and purposes, the New York e-sign should be enforced based on that decision.
But what's fascinating, I mean, you and I have talked about this, is that I think when it comes to the authentication of electronic contracts, I think there's no question in the law that an electronic signature indication of the party's intent to be valid is valid. A more interesting question is posed by what Joe was talking about before, the hybrid contract, where a portion of the contract is simply not in any human language, it's in some form of computer code. And the case on that is there's a much greater dearth. There's really very little on that, although we found a fascinating Supreme Court case, interesting enough, from 1886, Roberts versus Finn, cotton merchants had entered into a futures contract through their agent that went wrong, as futures contracts often do. And their agent, the broker, settled the contract nonetheless and paid out about $20,000, $11 these days. And the merchants sued and said, no, you shouldn't have settled that contract. There were no defenses. There was no valid and binding contract because there was no writing. The statute of frauds, which you referred to, applies here. There was never a contract, so you shouldn't have paid. Please give us restitution. And the Supreme Court looked at that and said, well, why do you say there's no contract? Because the contract was in code. This is what's fascinating. Cotton merchants in that day, to aid the use of telegraph communications, they developed a complex cipher called the Shepherdson cipher. And they had all these words and symbols and things and patterns. And names, Bob, that meant 3 bushels of cotton or something. They'd write these things, Bob and Jane, go to the store, whatever. And it made no sense. And it had some other symbols in it. But it was a code. And the Supreme Court said, but that's the code that the Cotton Exchange endorsed for commerce. And that cotton traders would understand that code. And if cotton traders could understand that code, it was valid and binding in writing, notwithstanding the fact that it was not in standard language. And I think we can take from that case a number of things, but one is the point that David made earlier, that generals have an inherent sense of equity. And if the parties knew what they were doing about mailing, and the any smart contract that we do, they're going to find a binding agreement there.
And I think what's important to note is, we're talking about the U.S., right? We're talking about New York, but having spoken to a number of our members, especially in the trade finance world, their biggest concern is that there are still jurisdictions out there that do not accept or acknowledge electronic signature. right? So there's a huge addressable market, I think, as Joe mentioned. And there's still bills of lading that need to get stamped by a captain's kind of work, right? A piece of paper and get faxed. I think the one caveat just kind of understand that, this is New York, this is the US, but, as you kind of want to expand this globally, which, obviously there's a lot of talk about that, there's a lot to be done in terms of regulation in a number of other countries.
I have an illustrated story I have to tell. It's about 30 seconds to tell the story. We had a client that had gone to a law firm in China and said, can we use electronic signatures on our contracts in China? And the law firm in China came back and said, yes, in 2004, the Chinese government adopted electronic signature statute. In fact, very similar to the US e-signing. And so, yes, you can use electronic signatures in the contract. Well, they started to do that, but then they discovered they couldn't get them accepted by any governmental official in China when they went as frequently you had to do in China. You had to actually register these contracts and approve. They couldn't get them approved because they did not have what we colloquially in the United States would call a chop, a stamp actually added to the contract. And so the client went back to me, as I should mention, the client has told the story multiple times in the book. The client goes back and to the Chinese law firm and says, what the heck? You told us we could do this electronically. And the firm looked at them and said, well, yeah. You sign it electronically, you print it out, and you have the stamp stamped on it. So you got a lot of the moral story is that there's lots of variations out there, and you have to understand the culture that you're dealing with as you move forward.
Yeah, but I think, at least in the US and most Western industrialized countries, this presumably should not be as big.
I would like to follow up on that and ask the rest of the panel. I wondered about Europe. They do not necessarily have the common law tradition, and boy, they had trouble even accepting electronic signatures, other than what they call qualified fugitives. So I'm curious what you think about Europe.
I agree completely. I think Jason's the point that you're alluding to. It's a critical one that for those of you who are lawyers understand the common law system, the civil law system, the common law system, the final arbiter of law, basically the judges. So as David and Joe were saying earlier, that's a critical piece of the puzzle when judges, when there's no clear law, the judges in the common law system can look at that and reach a conclusion and that decision becomes law. That's just not how it works in the civil law system. If there's not a statute, if there's not a clear directive from the government of some sort or another, it doesn't work. So I think you're right, and I think this is another area where potentially, again, the common law in US, UK, Canada, Australia, etc., have a big step ahead in the flexibility. So I think Jason, their point is critical.
Yeah, and I think I forgot which country. There's a big notary lobby in some Nordic country where contracts have to get notarized, right? And apparently that notary lobby has a lot of power, and that I forget which country it is, but that still exists today, and even in the westernized nation, that's still there.
Well, and a lot of civil jurisdictions in particular, notaries make multiple lawyers. Actually, it's a very lucrative. And these are often set by statute or unwaivable.
So there's definitely complexity with enforcement, and I guess the only other point to make, I guess UETA, ESRA, could break down, or do they break down when we begin to think about machine transactions? What are the limits? Where actually can we improve them?
I think that there's some infirmities in the actual language of the statute. If you actually look at the commentary kind of goes a little farther than the statute itself. The statute talks about I'm actually afraid of the thing out because I can never remember the term electronic agent is a computer program or electronic or other automated means used independently to initiate an action or respond to electronic records or performances in or in court without review or action by an individual at the time of the action or response. I think the court would really hone in on that without review. They might say there's some limitations. And you don't get that feeling from then there's comment, which really goes a little further maybe than that. I don't know how big a real obstacle that's going to be, but I think you can certainly have some of the argument doing something that can.
I'd also suggest that courts oftentimes have to hear very technical cases that are well outside their scope of expertise, but have to have expert, witnesses. And as long as you're not using an unfamiliar programming language, you're not going to have a hard time, getting experts who can come in and say, this was supposed to be A, B, and C.
All right, so maybe one last question we'll open it up to the audience. So it seems like smart contracts are here. They may be here to stay, but so increasingly they will be demanded by our clients. So, what's it going to look like for the lawyers over the next 10, 20 years? Are we going to see more Deweys being minted, programming lawyers? Are we going to see law firms hiring programmers to work with the clients, to put these things together? How do you see it playing out?
I would say both.
All the way,
Yeah.
all the way.
Because I think, you have to also know what your limitations are, just like, a finance lawyer, so I would handle a family law case. It's the same thing, you may be confident to do a letter of credit, but not a life insurance policy. So in something more complicated, you probably need engineers working with lawyers that at least understand the terminology.
And that will be a challenge for the legal community because I've worked for a number of years at Wells Fargo. I was working on electronic financial services new product, but a huge interaction with product. One of the things I learned very quickly is that an awful lot of IT folks are extremely smart, extremely quick on the uptake, but they're also pretty literal. And so the kind of colloquial language that lawyers tend to use sometimes with respect to how something should work or what the requirement is does not translate well. It's kind of like the old joke about you start with the phrase that flushes the spirit is willing, but the flesh is weak. We translate into Russian, we translate it back, and it comes back. The line's pretty good, but I think the meat's more. Okay? That's kind of what happens sometimes in conversations I would have with the IT department in terms of what would come back. So one of the things that will become, I think, an important skill set for the legal community is being able, a much broader swath of us, to be able to communicate effectively with IT developers. And the flip side of that is we will have to find IT developers who can work with us and are able to essentially take the legal concepts and the legal constructs and integrate them into a program environment.
I'd second that strongly. The term we use in our firm is blockchain lawyer. It's not necessarily a coding lawyer. You may be fortunate, like Joe, to really have a background and a deep understanding of coding. That's interesting, but less critical than understanding the background of the coding and being able to communicate. Because I just want to bring out an interesting point, Aaron. That's professional responsibility, the rules of professional responsibility. Where's the liability? So if code gets written that has defects, we have, in commercial terms, an understanding of service level agreements and requirements, et cetera. Lawyers don't have any of that. We have very different standards. And, I suspect, it's fantastic to have the depth of skills of someone like Joe, but at the same time, when it comes to actually delivering the code itself, it may be more appropriate for a coding firm, a technologist to do that. And what you want are blockchain lawyers, like, some folks who can really understand that. So I think, David, that's a critical point.
Of course, my contractor is better than my coach. No, but that is, there's also a point at which you can provide client value with proof of concept and things like that. But you have to know your limitations. And some people are, software engineers, or that's what they do.
Yeah, and transactional, I estimate that there's a $161 billion a year industry. So if this is going to impact the number of different contracts, then there's a lot of opportunity there for those who work in this space. So maybe we can stop there and we can open up for questions. Yeah.
Sure. Most of my career has been in the structured finance like tax space, and what you guys are touching on towards the end is something that in our business we rely on legal opinions for tax reasons, like So if I'm looking at a contract now that's proposed by reference as part of the contract, as a law firm, they're going to be able to provide an opinion, the technology opinion, that I can rely on, because I can read English, I read these foreign documents, I can code. And so the technologists may be the only ones that can read code. Will they be employed at a law firm? Will we be able to write an opinion? Hopefully not.
We actually do, one of the things that we do at the moment that's a little unusual is that we, for example, at BuckleySandler, we do reasoned opinions on electronic contracting. And we see a fair amount of that work because that's still something of a specialty. A lot of law firms aren't comfortable doing it. I think you're going to see that happen in this space as well. You'll have lawyers the folks that are getting into this now who will get comfortable with it. They'll figure out how to do it. But one of the things that will be a significant kind of a breakthrough, I think, will be to what extent will the law firms when doing these opinions say, here's what you told us about how the programming works. We're taking that at face value, and here's the thing. Versus, we're actually going to hire someone, or maybe we have folks like Joe, who are capable of doing themselves, that are actually going to go and kick the tires. And part of the opinion is that you kick the tires yourself. I'm not sure how that plays out.
Well, it's not exactly, just a law firm's decision to make. I think we have carriers who we're going to have something to say about that.
The insurers, yeah.
Absolutely.
Carriers,
No question about that.
But one thing you can emphasize with smart contract code, you can actually run it before it's executed, right? So that's one of the nice things that actually gets introduced by this. You can model out an agreement and press play and see all the closed payments or other things that will occur before the parties execute. So maybe that's interesting. Also, with bankruptcy, there's issues doing the automatic entry of smart contracts, how that will interface with the bankruptcy, the various automatic stays and other things that are required for business bankruptcy. So I think that also adds some information.
Following on that, talking about variances, that rightly saying that within website, so the EA said that all of everything we're reading here is the code is the real factor. We're supposed to that, but of course there was a mistake in that. So I wonder if that to what extent entering into a contract that was not
So I prefer spectacular disasters. So the DAG, just for some background, it was a virtual corporation that was modeled using smart contract code. So people basically bought an interest in this virtual venture capital fund that was getting set up, and people bought an interest in it, and the venture capital fund generated a profit, and again distributed to parties on a pro-rata basis. And the debtors had the opportunity to dictate where certain funds would go. And there was a very short-term conditions before you purchased the beverage of interest, which basically said this entire arrangement will be governed by the smart contract code. A very short, semi-line file, semi-line facility file.
Well, I think it's hopefully different slides here. It did help that error in from 2 months leading up to it, and then having a catastrophic implosion. But again, I don't know why we wouldn't apply the same, common law doctrines we have from the state or Someone might do a gross contract and say it's the most ironclad contract ever, except it's not. Now, of course, this is the real difficulty. There was no way to fix that issue without connecting everybody else. The ledger. That's very different. They broke the ledger. They broke the ledger. Yeah. They broke the rails. Yeah.
I do think he's unlucky. Assuming everybody was in the US, it's strictly because local. But assuming it was in the US, a court would presumably look at it, they would assess whether or not this was an balance of agreement, and if it's unambiguous, then I agree with the whole. I think that there was a good argument that this was not the intent of the parties, it was a bug could be considered a mistake or something that would make the contract ridiculous, and therefore, was looking to what the parties were actually contemplating. Potentially a market.
There was no design to argue that the contract was law, that if you found a product
Yeah, I would say the people who said that were not lawyers. One thing I think just realize these things are not cooperative back into a rich history that's been developed over hundreds of years. Even contracts been around since Mesopotamia. We've been doing the same thing with arrangements for those who lost it. I don't think it's
I would actually differ with that. We can talk about that afterwards. I'm not sure I reached that same conclusion, particularly because the parties went out of their way to specify that they did not want, and that was not the terms of the arrangement, to revisit what this code was. I think they got the right medicine. I think that was the right result. That's just one
that's proving that maybe to extremes of evidence is necessary. Yeah, there's many layers. It's a law school exam. So,
Just call it a hedge fund instead.
yeah, the security, a number of issues that were presented by that.
Yeah, just following up on that, in the aftermath, and sort of going back to your point about how one multiple vendors, one contractors got this provide, inability to take back, what was done, what provides some sort of certainty. In the aftermath of that, they forced the hearing on it, and sort of completely undermined the idea that our contracts are, they are, and you can't turn it back, but they did. In light of that kind of risk, I just want to know your ideas on that sort of event, because that's something that you can't really happen with the real contract. You can't just say, okay, we're just going to erase it and redo it there, erase it.
The one thing I point out is I'm not sure you have the same result with every, like if it was on quota or hypermeasure, where you almost have isolated contracts that you may have consensus as to when that contract happened, but it's still a self-contained. It's almost like parties are maintaining their own ledgers. So I think in some protocols you could go back and a court could have that one transaction unwound without like rolling back the entire ledger.
We kind of got through the decentralization and the diversified definition, saying that our contracts all we're going to be watching, but how much is that? How much of that is why is our contract between ourselves? Why is it not contract?
Sure. So I would say can you build digital contracts that don't rely on a blockchain? I think the answer is yes. But even within the context of blockchain technology, there may be different ways to structure these types of arrangements. So you could have something getting sort of like a multi-sig counter and having a constitution put on separate information. So I don't think it's pretty cut. I use the word definitionally, so that way just because it seems like small contracts feature in the theory sense of the word are here to stay. So I think it's best to choose that the broadest possible definition. disclosure.
Just to remind yourselves, of course, and many folks know that the term was coined by Nick Szabo well before the blockchain era. So, I mean, certainly it's the piece that the fundamental idea is not necessarily tied to blockchain.
Yeah, it's also very broad in its definition. It's a shame that we have that term, but it is kind of what that's why I try to call them smart contract programs, I think that makes it clear. I know the argument about whether or not it's a program, it's a computational mechanism, but I think that helps clarify what they are.
For example, what happens to litigate, no ask about business, what happens to litigate, all the cases in the contract good, contract object?
It isn't today, I don't know why that would change. There are so many shades of gray, it just isn't even funny. Even if you look at something like, is this electronic contract enforceable based on the way it was presented to the counterparty for signature or reviewing signature? There are enormous, among the cases that are out there, just on that issue, there are enormous shades of gray. Okay? You can draw some principles that are likely to keep you out of trouble in most cases. But if you look at where the courts are drawing the lines, there's an enormous gray area. There are cases that are contradictory, decisions that are contradictory measures. I don't think that's going to change. We're going to, over time, the beauty of the common law system is over time, broad consensus tends to develop, okay, with respect to key issues. But it sometimes takes time, and in the course of doing that, there can be contradictory opinions expressed that get tested against each other. Eventually, a consensus emerges. And that's actually part of the strength of the system. In my opinion.
Gotcha. So we can understand how time walking, very structured. My question is what happens in the case of on case or it's contract on the expenses so the nature of the contract is not big. But it's not 35 pages. Understand and change over time. That's what the challenge is to change voting and all that. So that was discussed. You guys see that the limitations will go to that space or the language, certain language that's involving that passing the case of the first natural and we're really about taxes on the extent.
I think verifiable, highly commoditized legal work is probably the area that's most right. But you're presumably pointing at manipulation contracts. We just look at actual to do kind of what Dave mentioned before. We're just sort it out. We just really want to figure it out. I think that's far off. The programming language that goes through right contract solidity is cocky. You're going to program it. It's not. It's great that we have it. It hasn't been anybody happy with it. I compared it to programmers back in the 90s. Using crafted on web, these Perl and Wright it. Since then, there's been so I do think it's not just in one institution, but it's commoditized legal work that makes sense. Maybe use it for automation.
I was just going to say there may be other asset management considerations that you just reduce the cost of managing, let's say, a portfolio of retail centers.
I'll give you a good example that I like to use. So imagine you have a company. Company documents for most small companies are fairly standardized, and you often introduce people offer letters on which I sometimes payment. So right now, we get paid presumably every 2 weeks. If we move to an entirely different world, where we have to on board with traditional fiat currency and seller, you can build a smart contract pay people every 10 seconds. Right? I mean, you can begin to imagine we get different. That's something that almost everybody deals with. And payroll processors will disappear. It'll be memorialized as a business some sort. And maybe that's better. But there's trade-offs in that. You can still improve that, but I think there's a certain highly commoditized work that runs needed a small firm too, is actually automated. and small contracts are part of that, it should be a broader automation.
I think one way to connect maybe the institutions with the consumers is and KYC work, right? Corporates have, legal entities, you have individuals that are coming to banks that need to get onboarded. And so, a lot of institutions right now are trying to see how we get that on a distributed ledger. So that might be kind of on the institutional side, where they see value in actually bringing this to, an individual kind of go from there. So, and I think just in general, personal identity, right? I mean, just storing of identity, whether it becomes, kind of an individual owns their PII, whether there's some kind of oracle system from, some government agency. There's still the connection to, commercial entities and institutions. So that might be the bridge that I think might get it to.
The financial services industry has a thing they call the ATM law. The ATM law is all technological advances are, the impact of all technological advances is overestimated in the short run and underestimated in the long run. And so if you think about companies right now like legal, they're going to be thinking about how do we manage to move some of this functionality and implement it in a way that will help small and medium-sized businesses. It won't necessarily be apparent today or tomorrow or next month. But I do know this. 25 years ago, I was doing my income taxes by hand, and it took me something like 10, 12 hours to do them. Today, my income tax return is 10 times as complicated, and I just did this year's return in 3 hours tops, okay, using TurboTax. And so the moral to that story is these kinds of tools tend to start out maybe being used by the big and the bad, okay? But the opportunities they present potentially can find its way into the field market. And so I think that folks will find innovative ways to take those tools and make them fit in the kind of business.
I would just say that coming back to where we started, the efficiency of commerce. There's a gentleman in the back, I know.
These are the Dow security, and what would the elements of the Dow, what the elements of the Dow security?
It's a great question. Anybody want to take that?
I can't recite the habits of that.
We actually had a program about this here a couple weeks ago, a couple months ago. I think if it was solely limited to the U.S., it's a question of whether or not it's partnership. Presumably, we're going to use a partnership, and partnership can be these securities. So, if that's the case,
But there was the interesting question about external management, because that's inherent in a security as it's managed by others, and that's a key part of how we test. And it is a very interesting case, because it was the Slacker guys wrote the code, but after that they didn't have an economic interest in that, best as I know. Well, I don't know. Okay. That made me wonder everything.
But I would say that if you're trying to build a virtual corporation in self-interest in that virtual entity, you're going to need to really carefully consider some of these young features.
I had a question sort of about in production, how contracts are actually carrying out what currency is being used, and also, is certain currency being used, or is traditional bank currency being used? How can a contract execute from the normal bank account? Are there sort of limitations that are in place now, infrastructure limitations that don't allow you to connect to regular banks? Is that sort of delaying from
So to your point, I think one of the key things that police are looking at is interoperability into legacy systems. A question that we get a lot from central banks is digital currency legal? And how do you represent cash on ledger? Let me put it out. So obviously, from our point of view, the best result would be a digital fiat currency issued by a central bank. So you had, Bank of Canada, Monetary Authority, Singapore, other central banks, working with our Treasury, with our members, to kind of see how that would look. So that would be the future state. I think right now, to your point, interoperability is going to be a very big aspect of this, both with legacy systems and, we mentioned, with other blockchain or distributed ledger systems as well.
And yet, right now, it's all in some sort of cryptocurrency.
Like Hyperledger, they imported, they don't have a native cryptocurrency, so sometimes it's just settlement of trades and
I just, but I think if you actually want a production grade release, like, you're probably going to have to hear the cryptocurrency or the digital currency of some sort. But maybe you could use oracles in the interim.
it'd be interesting to see what the Northern Trust production system.
Yeah, I just follow up that, or if we could, deploy it on and for the long values, right, for those, currency as opposed to very digital currency.
Do you mean like sending a signal, a Swift code message to?
Well, some sort of validation.
You could, it sounds scary.
The interesting thing is that some of the infrastructure to do some of the integration payment system you're talking about is probably in nascent form right now. As a result of the CFPB's recent announcement concerning the right of consumers to have access to consumers chosen aggregator to have access to financial data. A lot of the large financial institutions are in the process right now of developing essentially relationships and sharing APIs with these kind of entities. Tie that then into the rollout by the Automated Clearinghouse, the North American Clearing Association, of the same day debit and credit settlement system for ACH. Tie that into the Federal Reserve's Faster Payments Task Force, which is looking for an even faster way to move funds in the United States, which already exists in Europe. Right? So you look at all that and think about how all those pieces of infrastructure can fit together, and you eventually get to, we're starting to build the infrastructure to manage to tie some kind of blockchain delivery system into the delivery of fiat currency through some kind of integrated signal system. It doesn't exist fully today, but you can see it coming. It's on its way.
I think Napster brought us Spotify. It's going to bring us a digital currency.
Some saying before that are increasingly sophisticated right-related payment systems such as those for royalties, micropayments, and the like. We haven't, I think, thought of that contract. Now it seems like there's a blurring of the lines of where is the contract stopping the payment process to begin, or was it these beginning to blur and ultimately?
Always been blurred. It's been blurred since the beginning of time. It's just evolved. I wouldn't say that's my personal.
I do think microtransactions are an interesting use case. They're interesting behavioral issues with the potential costs for these people getting early on and small transactions. But putting that aside, so you can work that. I know that there's a number of companies that are use a smart contract for the agents that come in and create this related to contracting online.
Now, I want to come back to the point you made earlier, because it's very important what you're saying, that this critical distinction between delivery versus payment, which is really not a contract in a meaningful sense. There's no executory nature, there's no passage of time. Really, the critical element of a contract is that there's a passage of time and a promise that will be performed at a point in time in the future. And I think that's where some of the most interesting questions come up. The easiest applications are these, whether it's a royalty split or whatever it is, somebody has to exchange things. That's relatively easy to foresee. And the bigger legal challenges come up when there's an executory arrangement. And Aaron, you touched on some briefly when I spoke about is a very basic U.S. principle of law, the automatic stay. We want to put in place these automated commercial arrangements which keep performing on their own over time no matter what. But there's a big no matter what out there, and that's the bankruptcy of a commercial party. All enforcement, all has to stop at that moment in time. We don't have a system to query whatever it is, 700 district courts to find out at this moment in time the commercial party has actually commenced insolvency. And if you continue to, accept payments or money from the insolvent state, you have to disclose those. So there's some real interesting questions.
Bear in mind that when we say interesting, it's sort of like having a document that you're actually going, well, that's interesting.
A little procedure.
So this kind of follows up on that. If you draft a smart contract that's dependent upon oracles in one country, is that creating some sort of centralized data mechanism? That data input gets corrupted or it's got the wrong data. That contract would then execute on it and eligible with that. And is maybe there's some way to integrate the data stream of the Oracle into the blockchain itself.
I think this would be let's say hypothetically, Bloomberg's a pretty stable company, they should be able to have a very high responsibility that it will be there if your contract is term, right? For some, couple years, 5 years. But you could also do a bundle of if this meets their goal, this other need, or if not, then just stop the contract, pop it out into some other state. So I think people need to figure it out, but I don't know if there's a second point. It is a point of notice. I do think this. I think if maybe the oversight we can decentralize all those, have some samples, which might value stuff, trusted. But I think it's an interesting question that people don't like.
And some have tried to come up with more complicated,
Yeah.
game theory based wagerism. Yeah, exactly.
And I think from a regulatory standpoint, there's also questions about business continuity and disaster recovery regulations that banks have today. So if they have a smart contract with an Oracle that does fail, and that smart contract is decentralized, where are the backups, right? Where do you store the data that you need to store in order to comply with regulations? And that could potentially be that disaster, which the regulators would want to avoid.
So this was regarding the school percentage contract. But we didn't do the final offer. Remember that the argument that there's no central location.
So I think it's really fascinating, right? So one of the advantages of automation is efficiency, like Lewis was mentioning, but another advantage of automation is that it's hard to stop. And if you are somebody who wants to develop a legal contract, this is at the most countries have laws against gambling. It really becomes difficult to stop these types of quote-unquote legal contracts. Unless the parties are identified, then they can be possible.
Well, it is sort of interesting, the interns that were out of town, and they just ran a centralized version of all of it. They weren't located in the United States. They chose to do the right thing and stop soliciting.
Also, just remind ourselves, you could be Kim.com, right? Or he's good for now, he's going to be extradited soon, probably, not so much, right? So, you think you're good, so you're not. Yeah.
I think there's something interesting that you know, one of the first examples is what contract program was in the casino. So a really basic one that probably was hard to store, but I think that point is that you can actually now have autonomous systems making virtual currency account blockchain, and people can draft, because there's some really, how do you stop it?
If it's a mutual system, then that's actually not illegal, right? What's illegal, a gambling contract is not enforceable, but it's not illegal if it's so you have your office pool, and it's a mutual, it's a zero-sum game. I understand, so there's nothing illegal about it. You're not violating the law, if somebody doesn't want to pay, you can't take it to court.
Except the prediction market stuff and then the commodities.
Well, that's a different idea.
So I'm a legit attorney, obviously fine with sharing the application and talking to things like recording title and this and that. I'm also learning about Cook County and I'm going to be the first pilot program and understanding Cook County verification, not quite transparent, efficient, et cetera. So I'm wondering from a perspective,
I'm very much like Kansas in Chicago, I'm in Illinois. And one of the things that's kind of interesting about that title in Cook County is that if you know enough about your Cook County history, it's back to the future. Cook County was one location in the United States that used what was called the Torrent system for recording. And basically it was a very, very non-forgiving, once it's done system. And one of the concerns, of course, that's been expressed about trying to use blockchain ledgers for those kinds of transactions is that they do not necessarily lend themselves to correction of the erroneous transfer very well. You almost have to have the structure built so that you can layer the corrected transfer as an additional lockout layer onto the chain. That's not to say it can't be done, but there is but it raises a bigger question, which is, are there certain kinds of transactions for which we will end up concluding as a society that intermediation actually has its own value, and we're not interested in disintermediating certain parts of the transaction?
What they thought of is it would be an interesting study is if you took half the title premium that you otherwise would have paid and dumped that into a fund for those instances where somebody somehow fraudulently dumped that and we were even out there.
No, well, as a matter of fact, there's kind of an argument that's gone on for years in most states is whether or not title insurance companies, instead of actually having to go examine title and get title cleared in order to issue a title policy, would simply be able to issue them on the same basis that automobile and homeowners policies are issued, which is based on actuarial risk, so that they wouldn't actually even go and examine the title. They would just say, well, what's the likelihood that somebody's going to try to claim they've got a lien on their house or they've got an easement against their property? It's X. And so we're going to insure against that on an actuarial basis instead of on an actual examination basis. And the answer that's come back from the state governments and the county governments is, you don't understand. That's not the actual ultimate value of title insurance as issued today. The value of title insurance as issued today with actual title examination is it forces the continual cleaning of the title record so that 30 years from now, you can tell whether or not you can buy this property because you don't have 30 years worth of garbage, stored up, creating questions about ownership, title, ability to convey that have not been cleaned out. So we're not prepared to allow the title insurance company to do this on an actuarial basis, not because we don't get the economics of that, but because there's another good here that's very important. And we're going to retain the existing system, retain that good.
Yeah.
Those are the kinds of conversations that are going to end up happening about some of the things that blockchain does.
And two quick observations. One, to verify, most jurisdictions other than the US don't actually use title insurance. Somehow manage to get along quite well. The other thing is we're working on that, the Cook County project, and offline, if you come by, I'm happy to talk more about it.
Any other questions? I will thank you very much.